Hello, everyone. This week, we will be going over a brief overview of all of the ways that psychologists can be involved in the legal system and in the law. We'll go into all of these in much more detail throughout the semester, but this is just to get us jump-started, have a nice overview of what we'll be covering. Now, as you read about psychology and the law, you'll probably run across this term quite a bit, forensic psychology. And you may even hear me use it throughout the semester. In fact, a course on psychology and the law is often called a forensic psychology course. So the term forensic is from the Latin. It means forum, and it refers to where the Romans held their trials. The current meaning is the relationship between one professional field with the legal system. So for example, you can have forensic medicine, forensic anthropology, forensic chemistry, in addition to forensic psychology. So there are several actual definitions of how we use this term forensic psychology today. So the specialty guidelines for forensic psychologists, which is a set of ethical guideposts, defines it as a field that covers all forms of professional conduct when acting with definable foreknowledge as a psychological expert on explicitly psychological issues in direct assistance to the courts, party to legal proceedings, correctional and forensic mental health facilities, and administrative, judicial, and legislative agencies acting in a judicial capacity. The American Board for Professional Psychology is essentially our board certification body, very similar to being board certified in medicine. They define forensic psychology as the application of the science and profession of law to questions and issues relating to psychology and the legal system. And in association with the American Psychology Law Society, which is Division 41 of the American Psychological Association, which has many divisions that address many subtopics within psychology, defines forensic psychology as the professional practice by psychologists within the areas of clinical psychology, counseling psychology, neuropsychology, and school psychology when they are engaged regularly as experts and represent themselves as such in an activity primarily intended to provide professional psychological expertise in the judicial system. Now, when I studied forensic psychology as a graduate student, I took it with Dr. Jack Graham, who is an expert in the field of assessment. And he defined forensic psychology as activities of mental health professionals as they deal with issues having to do with the law. So you're doing forensic psychology anytime you're offering services to address legal issues, anytime you're offering opinions or services to assist the legal system with resolving any issues. So you can be involved in many different ways. I'm not going to get too much into the history of forensic psychology here, but I want to give you a very brief overview. So in 1908, Hugo Munstenberg wrote On the Witness Stand, and he argued that psychologists should be involved in a number of aspects of the legal system. Many felt his claims were exaggerated, however. He had this 269-page text, and he didn't have any citations. Big no-no. Would be called plagiarism in today's day and age. So this was largely ignored at the time. As psychology grew as a field, psychologists were called on more and more in court, but they were often questioned because they didn't have an MD. In Brown versus the Board of Education in 1954, social science research was cited to support the negative effects of segregation on the self-image of children, in particular groundbreaking research by the Clarks, who were psychologists looking at how children responded to African-American or European-American dolls. And these African-American children would say the European-American dolls were prettier, smarter, very heartbreaking. In Jenkins versus the United States in 1962, psychologists were first recognized as expert witnesses. And then it took till 2001 for forensic psychology to be officially recognized by the APA as a specialty field with Division 41. There are numerous training opportunities now for psychologists who wish to go into this field. So what do forensic psychologists actually do? Uh, if they work in the field full-time, then they are hired by several different entities. So they might be employed by some part of the judicial system. So they might be hired by an accused criminal or working for a specific attorney or firm. They may be working directly for the court system. This is very common in family courts where a lot of child custody hearings have to be accomplished, for example. They might be working for a specific government agency like the FBI or the CIA. But unfortunately, as much as people love to think this is where they're going to go into, there aren't that many positions available in these fields. They also will work in correctional facilities, so in prisons. So forensic psychology is the whole process of this, and some people will say that correctional psychology is different than forensic, but most psychologists don't really make that distinction. However, most people who are involved in forensic psychology are not involved in it full time. Forensic involvement is just part of what they do, and they may be just called upon to do it rarely or occasionally. In part because it's this newer area of specialization, in part because sometimes they're doing a different job and they get involved sort of tangentially. So one of the things that becomes a question is who's going to pay you to do this, right? You want to get paid as a psychologist. So in civil suits, you would be paid out of whatever settlement is occurring or maybe by the insurance company. And in criminal work, it really depends on how you get involved. So if you're hired by the court, you would be paid out of public funds, and then you're working for the court. And then if you're hired, say, by the defense, then you're going to be paid by the defense attorney, who in turn gets their money from the client. If it's a public defender situation, then you'd be paid by the county. But there are several different roles that psychologists will take on in the legal system. And there are 5 distinct roles that we'll talk about today. So the basic or applied psychologist or scientist, the policy evaluator, the forensic evaluator, and the consultant. And for each of these roles a psychologist may take on, there are certain ethical standards of behavior they also have to follow. So we'll touch on each of those as we go through, because those in and of themselves, as you can imagine, can become important legal issues. So psychologists who work as basic scientists are just studying a phenomenon for the satisfaction of understanding it. They do not necessarily seek to apply their research findings, yet often the results can be applied to important legal issues. A prime example here is the work of Elizabeth Loftus, who you see on your screen. We'll study her more when we get to eyewitness testimony. She really is the biggest name in this area. Ethics here concern how you undertake and report your research. You can't fabricate your data, you can't plagiarize, you can't present a skewed selection of the data and hide the full range of your observations. And this applies to any psychologist doing research in any subfield. In essence, we are supposed to report what we find, regardless of whether or not it supports the hypothesis we originally came up with. The sort of classic example of what not to do in this area you may be familiar with, and that is the case of Andrew Wakefield, who was a medical doctor who was developing his own version of the MMR vaccine, and so did some research to try to discredit the existing MMR vaccine and claimed that it was tied to autism. His work had several flaws, ethical flaws, legal flaws. It wasn't approved by an ethics committee, which is required. He subjected children to invasive procedures without full consent by their parents or by the children themselves. So, for example, he took blood samples at his son's birthday party. What a great party favor. And he also manipulated and fabricated his data. So the Sunday Times in London broke this story. And they found that, for example, in most of the 12 cases he cited, their records actually showed something different than what Wakefield reported. And most of them developed symptoms of autism actually before they even got the vaccine. Now, this paper was actually retracted by The Lancet, the journal it was in, But as you may be familiar with, unfortunately, the damage was already done. And people still use this to cite a tie that does not exist between autism and vaccines. So this is just one small example of how important it is to behave ethically when we are collecting data. Now, when psychologists work as applied scientists, they often are testifying. And just like anyone else, a psychologist who happens to be involved in a case can just testify as a fact witness. Let's say you as a psychologist are part of an accident, you can testify on just the facts of what you experienced or saw. But you're doing that as a citizen and not as a psychologist in that capacity. Applied scientists, though, come forward as expert witnesses, and then they can talk about things they did not personally experience. So they're dedicated to applying knowledge to solve real-life problems. And as expert witnesses, they possess special knowledge about a subject that the average juror does not have. And by sharing that information, they may sway the jury one way or the other. They can state opinions and conclusions in addition to facts, which a fact witness is not really allowed to do. And they can be asked to evaluate the person and then testify, or just to testify based on area of experience. So for example, Loftus that we just spoke about often testifies about eyewitness testimony in general. So in terms of what are the criteria to be an expert witness? You need to be qualified. You have to have some training or experience in psychology, probably a PhD, probably very specialized training and experience. And again, you're only going to be called on when what you're being asked to describe is above the understanding of the average juror. So the judge has to be convinced that this testimony will require special knowledge or skill or expertise, and that it'll help promote better legal decision-making. If not, like, why bother, right? So psychologists have testified on topics like employee discrimination and the factors that may cause a suspect to make a false confession. Now, in terms of the ethics here, expert witnesses are often hired by just one side in a trial, but they are responsible for reporting all their conclusions, whether or not they actually support the side that's paying for them. You're trying to be objective, but it can be hard, right? It's a little questionable and has been historically whether or not expert testimony by psychologists is admissible in court. So in Fry v. the US in 1923, the decision was that to be admissible, testimony must be based on a generally accepted scientific theory. But like, who gets to decide what's scientific, right? We get a little fuzzy there. There were some negative implications of this, as new methodology couldn't be admitted as evidence until a significant proportion of professionals agree, even if it might help a lot in that case. Some states do still use this standard in deciding whether or not to allow expert testimony. In these states, you have what are called Fry hearings, a separate hearing to determine whether or not the evidence is admissible under these standards. Jenkins v. the US in 1962 was more specifically about whether or not psychologists could testify. Both the American Psychological Association and the American Psychiatric Association wrote opinions here, and the DC Circuit Court of Appeals ruled in favor of psychologists, and they said they could testify. They are experts. The judge here was named Bazelon. We'll hear his name quite a bit throughout the semester because he was very psychologist friendly. So he made a lot of decisions in our favor. And he cited psychologists' extensive training and qualifications. Another important thing to consider here is the Federal Rule of Evidence 702 from 1976. And this is for federal courts. And it says that acceptability of a new technique is not necessary for evidence to be admissible in expert testimony. So again, kind of differing than Fry there, but only for federal courts. The US Supreme Court has indicated in Daubert versus Merrill Dow Pharmaceuticals in 1993 that judges' decisions about the admissibility of expert testimony based on scientific knowledge have to be based on the validity of the science in question. The case here was about birth defects. Dow Pharmaceuticals was being sued because a drug allegedly caused birth defects when pregnant women took it. The Daubert decision listed 4 factors that judges should consider in deciding whether or not a testimony was admissible. So whether the expert's theory or technique can be and has been tested. Is it falsifiable? Is it testable? Whether it has been evaluated by peer review, the reliability and error rate of the claims, and the extent to which the expert's techniques and claims have been generally accepted by the scientific community. So sort of going back to Fry a little bit. The Supreme Court also decided that the Daubert criteria apply to testimony based on technical or non-scientific knowledge in Kumho Tire C v. Carmichael in 1999. This was a tire failure case. The tire expert who testified used a methodology he developed himself. Here, just like for psychologists, they said, okay, but you have to have some evidence to back it up, essentially. The psychologist can also work as a policy evaluator, and they use methodological skills to evaluate how well an intervention has worked. So does the specific intervention for released rapists prevent recidivism? Ethics here, you have similar ethical responsibilities to expert witnesses. So you have to report everything you find, regardless of whether or not it supports this program that you might have put a lot of work into. And regardless of possible pressures by the company who hired you to interpret those results a certain way. So again, also similar to the basic scientist, the scientific rules and ethics apply here. Now, the psychologist as forensic evaluator, I think, is the one that people don't think about that often, but as you'll see throughout the semester, is really where a lot of psychologists who work full-time in the field do their work. So here they may be asked to evaluate individuals involved in civil and criminal cases, to report those findings to a judge, and at times to testify about those findings. So competence to stand trial, not guilty by reason of insanity, child custody cases, all of these would involve a psychologist in the role of forensic evaluator. There are 2 different ways that mental health professionals become involved as a forensic evaluator. They're either court appointed or they're hired by one of the parties involved. So how they give opinions, and this often surprises people, is the first line is you write a report. And most of the time, vast majority of the time, that's all you do. That report goes to either the attorney who hired you or to the judge if the court hired you, or both. And then you're done. They take your report at face value. Lawyers will turn you down if they don't like your opinion. But again, similarly here, you want to be honest about your findings. Often you'll be involved in a deposition where you will be under oath and have to answer questions by the opposing attorney. You can ask to give sworn testimony under oath. This is a more rare scenario, but you would do this with an attorney present. And then again, rarely you would go to trial. Here you would offer your opinions, provide a voice, advice and evidence, and be cross-examined by the other side. One forensic psychologist I talked to, however, said she only did this maybe once or twice a year. Most of the time, the judge takes the report at face value. Ethics here, you have to comply with the ethical code as described in the Ethical Principles of Psychologists and Code of Conduct, and those specialty guidelines we talked about before. There are also specific guidelines for child custody cases that we'll talk about when we get to that point of the semester. Basically, these outline that your evaluations have to be clear in their purpose. You have to be competent to conduct them. You have to know what you're doing. You have to be respectful of appropriate relationships. You can't date someone you're evaluating. You have to provide the appropriate level of confidentiality. You can't go blabbing what you found to the press or all over town. You have to use methods and procedures, including tests, interviews that are accurate, current, and consistent with science and practice. And you have to communicate that appropriately in your report. Writing is really important for forensic psychologists because of this. You also usually, depending on the municipality, but very usually are not allowed to give an opinion about what's called the ultimate issue. So whether or not For example, that person is not guilty by reason of insanity. A lot of times you're not allowed to say that because that's something the judge will have to decide. Instead, you just present your evidence and talk about what you know or believe, but you can't say, I think this person is not guilty by reason of insanity. The other way that psychologists get involved, and we'll talk about this a lot later when we talk about jury selection, is as a trial consultant. So we'll use scientific jury selection procedures. We can conduct community attitude surveys to kind of get a feel for which way things are going to go. We can prepare witnesses to testify. We can advise lawyers in their presentation strategies and conduct mock trials. Ethics here, there is no expectation for impartiality in this particular role. You're being hired usually by that attorney. Psychologists as trial consultants actually will subscribe to the ethical code of attorneys. So the ethics code of the American Bar Association, they are there to assist the attorney in winning the case specifically. Sometimes these principles specified by the ethics code can conflict with psychologists' legal responsibilities. And when you go to group assignment 1, you'll talk about this with the very famous case, the Tarasov case, sort of a heartbreaking case. So the last thing that I'm going to talk about before I send you over to do that assignment is, what is the difference between a forensic psychologist and a clinical psychologist? Because this is a really common question that people will ask. So a clinical psychologist is someone who has a PhD in clinical psychology, who often sees clients, teaches, conducts research in a broad range of areas. And in fact, many forensic psychologists actually get their PhD in clinical psychology, but then they'll go on to get more specialized training to study and work in the area of psychology and the law. So big differences here. So who is the client? For a forensic psychologist, it's whoever hires you. So it might be the court system. It might be the police department. It might be the attorney. It's not the person you're evaluating a lot of the time, which is very weird for a clinical psychologist, who it's always that person right in front of you, the person you're treating or evaluating. That client is the person you're responsible to. What is the role of diagnosis? So in a clinical setting, you diagnose that person. It helps educate them about what's going on. It's important for insurance reimbursement. But for forensic psychologists, it doesn't map well onto legal criteria. It's almost irrelevant. They just want you to give evidence to support whatever question you're asking. Is that person competent to stand trial? Is that person guilty by reason of insanity? Continuous versus dichotomous behavior. In forensic psychology, you're pressed to make black or white statements, yes or no statements. In clinical psychology, you get to have degrees and continuums. Motivation to distort. You always assume people may be distorting when you're a forensic psychologist. Unfortunately, people have a lot of motivation to lie, right? Or at least exaggerate. So think about these motivations as you start that group assignment. In clinical settings, most are not motivated to distort. They want help. They might exaggerate just because it's a cry for help, but it's kind of rare. Temporal focus. When you're a clinical psychologist, you're focusing on that person right in front of you and what's going on with them now, and maybe how what happened in the past is relevant to what's going on now. Usually in a forensic situation, you are offering an opinion about their mental status in the past, when the crime happened, which might be a month ago, 6 months ago, several years ago. You sort of become a psychological detective, which is a struggle. Now, in standard of proof, in clinical situations, you're looking at statistical significance based on research findings, and also clinical significance. Does what you're doing actually make a difference in that person's life? Depending on which municipality you're in the legal system, there are different standards of proof. So, for example, if you ever hear beyond a reasonable doubt, the evidence has to be extraordinarily strong, like 90% sure. Clear and convincing is less than that. Preponderance of evidence is 51%, or I've heard some people say 50% plus a feather. So a reasonable degree of psychological certainty, you want to describe the basis of your opinion based on all the information available and explain why alternative opinions can be ruled out. Well, you're right, other people are wrong. So I look forward to seeing how you work with the material around the Tarasov case, and then you can move on to the second chapter, the second part of this module.